The time has finally arrived for Kouri freaking Richins to be sentenced.
Count 1, aggravated murder. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of aggravated murder.
And this is happening on May 13th of 2026, despite the defense trying to get that date postponed. They wanted it to happen on June 15th of 2026. I think upon realizing that, oh crap, Kouri's going to be sentenced on the victim Eric Richins' birthday? Yes, the judge denied the defense's motion to postpone the sentencing hearing. And so it is happening. In preparation for that, I want to show you what the state is recommending and just some details that, we learn now from this new document right before sentencing. So we'll go over that, but I just quickly want to tell you, if you're new to the case, don't worry, there's a whole playlist for you, as you can see, right? And so you can catch up here. You can also go and check out the trial days, which are all manually time-stamped for you by me. So you can check the pinned comments, look in the description box, or just hover over the video, and then you'll find all the witnesses that you might want to check out for the first time or just revisit. Where we last left off after the trial finished was the verdict, which you can see right over here, within 3 hours. I'm glad I put that on the thumbnail. Within 3 hours, verdict, And then also, what we did here was we analyzed what the jurors said the smoking gun was for them. So that was interesting too, based on interviews that they did with the media. And then, what's her second trial about? Because she faces 26 more charges. And she'll likely have a second trial if she gets sentenced to life without parole tomorrow. If I was her, I'd just plead guilty to these. Like, what's the point of going to trial again? But she seems to be somebody who quite likes the attention, the spotlight, and dressing up for court every day. So let's see if she proceeds with those charges and takes it to trial. That'll be quite something, hey? Also, is she going to be all dressed up like she was in her trial tomorrow, or is she going to finally be in her jail outfit? Her jail attire. I can't wait either way. So make sure that you are subscribed with your notifications on and don't miss out on when we go live for the sentencing that is happening on May 13th of 2026. Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. Now here is a new document, the state's sentencing memorandum. It's 15 pages long and it's got a lot of details in it that I want to make sure that we don't miss in case they don't say all of this out loud tomorrow. I don't know. So let's prepare for sentencing by reading this document together. In fact, you could just chill out. I'll read it to you, right? Thank you so much to Grizzly Cat for obtaining this document for us. So it says, in the 3rd Judicial District Court, Summit County, State of Utah, the State of Utah plaintiff versus Kouri Richins, the defendant. All right, so here we go. Judge Richard Mrazek. On Valentine's Day of 2022, Kouri Richins tried and failed to murder her husband and the father of her 3 young children, Eric Richins. Over the next 17 days, she did not think, what have I done? Rather, she thought, how can I do better? And then she murdered Eric in the presence of their children, using poison and for money. Oh man, you could just hear, this is written by Mr. Bloodworth, isn't it? You could just hear how he delivered those closing arguments. This is him.
She is intensely ambitious. See through her facade. Check her ambition. Do not let her get away with murder.
Such a person should never again lurk among the rest of us. Not live, not be part of. Just like she should never again even lurk among the rest of us. Her children should never worry that they may one day encounter her. Shame, the poor children. Accordingly, the state requests that the court impose a sentence of life in prison without parole. Mr. Bloodworth, he's speaking my language over here. Kouri Richins has earned it, because she's extremely ambitious, is what they said in closing arguments, the state, right, over and over again. Yeah, Kouri, you've earned this one. You win. You win this one. LWOP for you. Her children deserve it. Only this court can order it. You can do it, judge. You can do it. So it says state's sentencing request. 1. Count 1, aggravated murder. The court should order the defendant to serve life in prison without parole. 2. Count 2, attempted aggravated murder. The court should order the defendant to serve 5 years to life in prison consecutive to any other sentence. Oh, consecutive. He doesn't want concurrent. Consecutive. Count 3. Of course. I mean, obviously, why would the state ask for concurrent? Count 3, insurance fraud. The court should order the defendant to serve 1 to 15 years in prison consecutive to any other sentence. And as you can see, the insurance fraud is count 3 and 4, which are the same phraseology. Count 5 is forgery. The court should order the defendant to serve 1 to 5 years in prison consecutive to any other sentence. The court should enter a continuous protective order in favor of Eric Richins' family members that prohibits the defendant from contacting them unless they first initiate contact, and prohibits her from maintaining or benefiting from insurance on the lives of CR, AR, and WR, the children, right? Eric Richins' family members include CR, AR, and WR, Jean Richins, Katie Richins Benson, Clint Benson, MB and LB, and Amy Richins, and Andrew Swenson. 7. The court should order the defendant to pay restitution to Auto Owners Insurance Company in the amount of, damn, that's over $1 million, and True Stage Insurance Company in the amount of over $352,000. The court should order the defendant to pay recoupment to Summit County in the amount of $1.3+ million. Ooh, Mr. Bloodworth ain't playing. And the judge won't either. Argument. When sentencing, the court is to weigh and consider public safety, punishment, deterrence, incapacitation, restitution, and rehabilitation. State versus Klein. For consecutive versus concurrent sentencing decisions, the court must consider the gravity and circumstances of the offenses, the number of victims, and the history, character, and rehabilitative needs of the defendant. A sentence in a criminal case should be appropriate for the defendant in light of his background and the crime, his or her crime committed, and also serve the interests of society which underlie the criminal justice system. The court is to examine both aggravating and mitigating factors to include the nature and circumstances of the crime, the defendant's character, background, history, mental and physical condition, the impact of the crime on the victim's family and community, and any other facts in aggravation and mitigation of the penalty. There's also, obviously, you can see State versus Simpson. I'm just like skipping all the references instead of saying all these legal terms out loud the whole time, but you can read along with me, right? You can see it there. Okay, so it says, not all aggravating and mitigating factors are equally important, and one factor in mitigation or aggravation may weigh more than several factors on the opposite scale. A few egregious aggravating factors may outweigh several mitigating circumstances claimed by the defendant. We learned that lesson in the Tanner Hornet trial, didn't we? The psychological reality is that aggravating circumstances in first-degree murder cases will virtually always outweigh and be more compelling than mitigating circumstances, because the commission of a capital homicide, i.e. an intentional murder, is one of the most heinous acts known to society. The sheer emotional impact of all the evidence of an unjustified killing tends to overwhelm evidence of mitigating factors in the mind of the sentencing authority. The court is to consider the totality of the circumstances in imposing a sentence that is proportionate to the crime and the culpability of the defendant. The court is not limited to the circumstances of the crimes for which the defendant has been convicted, but may consider other factors as well. Oh, like her pulling faces throughout the trial? Oh, like the 26 other counts she faces? Evidence that is inadmissible at the guilt stage may be admissible for the purpose of sentencing. Nice. Such information must be reasonably reliable and relevant. Here, the state took the death penalty off the table in the early days of this case. It says, notice of intent not to seek the death penalty. Accordingly, on count 1, the court must sentence the defendant to either life without parole or an indeterminate term of imprisonment for 25 years to life. There is no presumption in favor of either of the two sentencing options. In totality, the egregious aggravators outweigh the perfunctory mitigators and require a sentence of life without parole on count 1 and consecutive sentencing on the remaining counts. Can you imagine her face when she gets sentenced to life without parole, which is what I think is going to happen, right? It says, 1. The court should sentence the defendant to life without parole on count 1. The nature and circumstances of the crime are irrational. The defendant murdered her husband in the presence of their young children using poison for money, and after trying and failing to murder him 17 days earlier. Oh, man. The Utah legislature recognizes that homicidal poisoning and murdering for money are each so heinous as to individually warrant the death penalty. Here the jury found the defendant guilty of both aggravators. The defendant chose poison. Jurists through time have recognized the particularly heinous nature of homicidal poisoning. Quote, of all species of death, the most detestable is that of poison, because it can, of all others, be the least prevented either by manhood or forethought, end quote. That is, it says, 4 William Blackstone commentaries. The Florida Supreme Court, hello Florida, has called poisoning a conscienceless, pitiless crime. The California Supreme Court observed, a murder carried out by deliberately giving the victim poison is more cruel and aggravated than other malicious or intentional killings, both because such a killing involves preparation and planning, and because the killer intentionally deprives the victim of any chance of escape or self-defense. True. Then it says, another quote, the poisoner acts surreptitiously, thus avoiding detection, often betraying the most intimate trust, end quote. Here the defendant betrayed the most intimate trust of her husband and her children. The defendant decided that Eric Richins' money was worth more than his life. Courts have consistently recognized that spousal murders motivated by money are especially egregious. In one such case, the Arizona Supreme Court observed the killing in this case did not arise out of the heat of passion, fear, struggle, or attempt to escape. This killing was not just the result of momentary premeditation, but of the defendant's deliberate, carefully conceived, meticulously planned, and cold-blooded scheme to kill, rather than divorce, his unsuspecting wife. That's a quote. The New Jersey Superior Court observed, these killings do not stem from some powerful visceral emotion, but rather from greed and expedience. Furthermore, few crimes display a more callous disregard for human life than the premeditated decision to seek profit by way of homicide. It evidences an abandonment of all the rules that society has constructed to maintain communal life and warrants the fullest condemnation and retribution. I agree, right? What a bunch of cowards, these poison cases, oh my word. And Eric Richins died from a fent overdose. B, the impact on the victim's family is irreparable. Fathers are not meant to bury sons, and losing a sibling is losing a piece of yourself. But there are no greater victims in this case than Eric's 3 young boys. The defendant took both of their parents from them. The aggravated murder was a crime of domestic violence in the presence of children. Eric Richins was a good husband. He cared and provided for his wife and even protected her from herself. Eric was a good father. He knew that the defendant tried to murder him on Valentine's Day, and he also knew that it was unsafe for his children if he were to leave the home. Eric died protecting his boys, and they know it. CR was 9 years old when his mother murdered his father. He's now 13 and wears his father's clothes to school. Oh man. Following Eric's death, DCFS supported a finding of emotional and physical abuse by the defendant against CR. See the state sentencing Exhibit A. He and his brothers have participated in intense therapy since the defendant was arrested 3 years ago. CR wants the court to know that my dad was a good person and very thoughtful and kind and helped whoever needed help. and that I'm afraid if she gets out, she'll come after me and my brothers, my whole family. I think she would come and take us and not do good things to us, like hurt us. I miss my dad, but I do not miss how my life used to be. I don't miss Kouri, I will tell you that. Man, coming from a 13-year-old, oh my goodness. He doesn't say, I don't miss my mom, hey? He says, I don't miss Kouri, I will tell you that. AR was 3 weeks shy of his 8th birthday when his mother murdered his father. The defendant made AR her alibi, thereby condemning her child to be a material witness. If called to testify at trial, AR would have recalled being put to bed early on March 3rd of 2022 without bathing, which was unusual for the boys. The television was playing loudly inside his parents' bedroom, and when AR tried to enter, he found he was locked out. AR used a broom to try to dislodge a key from above the door frame, intending to unlock the door and enter the bedroom. AR accidentally hit the wall with the broom, making a noise that attracted his mother's attention. She yelled at AR to go away. She later entered his room and asked him what he needed. Oh, this is a very different story to what Kouri tells, hey? Holy moly. Now we're hearing it. Oh my word. AR pretended to be asleep because he was angry with her. Later during the night, his brother WR woke and tried to enter his parents' bedroom to sleep with them, as was his habit. WR also found himself locked out and slept in AR's bed instead. AR would have testified at trial that the defendant did not sleep in his room with him the night she murdered his father, because that was her whole story. That she left Eric, they had a celebratory drink, you know, celebrating a property that she had secured, which he didn't even want her to, and that she then went to a children's room because they had night terrors, and then she went back to, you know, the master bedroom and she found Eric cold to the touch. Well, her children are saying something completely different. You know what I mean? This is, in my opinion, the truth. AR wants the court to know that my dad can't be my coach anymore and can't be at any of my games. He won't be at my birthdays, he can't teach me how to drive, he won't be at my graduation, and he can't take me camping or fishing. And that I don't want the defendant out of jail because, well, they put that in brackets, right? I don't want Kouri out of jail because I will not feel safe if she's out. With her in jail, I will be able to continue to feel safe and live a happy and successful life without fear of her hurting me or anyone I love. Remember that sick book that Kouri wrote, Are You With Me? That gaslighting of, yeah, your dad's always with you, don't you worry about it. Shame. Well, here you could see that that had no impact. You know what I mean? That's like, no, he's not with me. He's not at my games. He can't take me fishing. He's not at my birthdays because you killed him.
So my husband passed away unexpectedly last year. So it's March 4th was a 1-year anniversary for us, and he was 39. It completely took us all by shock.
WR was still in preschool when his mother murdered his father. He has now lived half his life without his father and 3 years without his mother. His memories of both are limited. He remembers being scared the night of his father's murder and wetting his pants while held in the bedroom before his Aunt Katie arrived. WR wants the court to know that when someone talks about Kouri, it makes me feel hateful and ashamed. She took away my dad, and that if she got out, I would be so scared. I'm worried that she would take me away. Once she is gone, I will feel happy and I will feel safer and relaxed and trust me people more. Listen, Judge LWOP, okay? Life without the possibility of parole, please. Even just for the sake of the children, right? Yes. If the defendant serves 25 years in prison, she could potentially be paroled at age 57. Her sons will be 36, 35, and 30, and likely will have their own families. The boys deserve finality and should not have to revisit their father's murder at future hearings or worry about the defendant's potential parole. Given the tremendous trauma and upheaval that the defendant inflicted upon their childhood, this court should ensure that she does not harm their adulthood. Not only should the defendant serve her life in prison, but she should serve her boys' lives in prison. This is the best closure her children can hope for. Only this court can give it to them. Katie and Clint are now raising 3 boys that require extraordinary love, support, and stability. It is best for the boys and everyone is thriving, but Katie and Clint never planned for it. Katie never planned to administer an estate and a trust or tackle vindictive litigation. Gene never planned to work the family ranch at his age without Eric. Katie and Amy both live with guilt for not doing more to protect their brother from his wife. The aggravated murder's impact extends beyond Eric Richins' family. Josh Grossman bears the weight of knowing that he contributed to the defendant's motivation to murder Eric. That was her lover, right? Paramour. It has gutted him. Chelsea Barney bears similar weight, knowing that the defendant murdered Eric in some measure to salvage Miss Barney's life savings. It haunts Carmen Lauber that she unknowingly provided the defendant with the fatal drugs. Cody Wright and Josh Case question whether they could have done more to save their friend. C. The defendant's character is irredeemable. The defendant is transparent. Evidence of her character is well known from all stages of this proceeding, to include her prioritizing a facade of success over everything, her fraudulent borrowing, her stealing her best friend's life savings, her persistence in murdering Eric after failing on Valentine's Day, her self-publishing a children's book for money and attention, and the aim of her walk the dog letter, among a slew of other examples. The defendant cannot check her ambition or her sense of entitlement. When confronted, she lies. When she feels aggrieved, she attacks. And she certainly feels aggrieved. She always has. In the immediate aftermath of the guilty verdict, the defendant blamed a corrupt prosecution, a corrupt judge, and unfair Summit County jurors. She went all baby girl on them? This was not fair. Everything was corrupt but me. She needs to stare into a plastic mirror a little longer, hey? So it says, see example state sentencing exhibit C. 6 weeks following the guilty verdict, the defendant text messaged an admirer. Now, whoa. Listen, admirers, no. Hybristophilia is not cute. It is a disorder and people need help for it. But please, please, there's nothing to admire here. She's a killer. She killed her husband. Yeah, with her children in the home. No one wants that? Okay. This is what Kouri said, right? 6 weeks following the defendant text messaged an admirer. She said, I will expose this county, the prosecution, the judge, the Richins, the investigation, all of it. So they can lock me away for now. That's fine. It's going to come back on them. It will come to an end. Not this year or next, but I'm not going away. I won't be silent. I am going to expose them all for what they've done to me, my kids, my family, this injustice. They picked the wrong one. They think sentencing is the end, closure. It's just the beginning. They haven't seen anything yet. Wink. Okay, Kouri. Yeah. You're like, they picked the wrong one. Oh, you picked the wrong one. This judge is not going to play. The state's not playing. Your children, they want nothing to do with you. Like, when is she going to get it? Is she never going to get it? She sounds like Sarah Boone over here. But worse, you know, she's worse. In my opinion, she's worse. It's all bad, all terrible, all killers. But like, damn, Kouri, damn. Okay, see state sentencing exhibit D. Most telling of her character, the defendant attacked Eric. Within hours of her arrest, she for the first time blamed Eric for his own death. See the state sentencing exhibit E and E to T. From jail, the defendant and her family engaged in open season on Eric the Dead, releasing what they believed to be damaging information about Eric to the media. State's memorandum opposing motion to suppress letter. During trial, the defendant falsely accused Eric of having an affair with a co-worker and a homosexual affair with one of his best friends. That was so ridiculous. Oh my word, the defense should be so embarrassed of themselves. The Richins children are familiar with the inescapable media coverage of this case. Many of the defendant's attacks against the Richins family permeate the record. For example, she throat-punched Amy Richins 2 days after murdering Eric when Amy informed her of the Eric Richins Living Trust, the trust. Eric created the trust to protect her and their children. 4 days later, she hired counsel to breach the trust. She told Jean Richins that Eric died of the same lung mold that killed Jean's wife. That is just, again, next level cruelty that she did that. It says cruel. In the walk the dog letter, the defendant instructed her mother to release photographs of Katie's young children to the media and wrote, "Bring me home and then we'll get those damn bitches," referring to Eric's sisters. See DKT 214. When confronted with the letter, the defendant insisted in the face of all reason that it was part of a freaking book. Okay, so that's why we say Kouri freaking Richins. She talks like that. It's part of a freaking book. Okay, Kouri freaking Richins, LWOP for you. A half-true, half-fiction novel about her incarceration. Other of the defendant's attacks against the Richins family are new to the record. Spill all the tea, Mr. Bloodworth. For example, we're listening. When the estate's investigator found bank statements with Kouri Richins' realty account header and C&E's account details, the defendant accused Katie and hired counsel to advocate for the criminal prosecution of Katie. While detained pre-trial, she caused her family members to pursue federal firearms charges against Jean for removing Eric's firearms from the Willow Court home for safekeeping, file false reports with DCFS against Katie, and to report Amy Richins to the police for MJ possession. To this day, the defendant maintains insurance policies on the lives of her children. The Richins family will not be safe if the defendant is ever paroled. The defendant's attacks extended beyond the Richins. While detained pre-trial, the defendant caused her family members to file unfounded bar complaints against the Summit County Attorney and the Chief Prosecutor and post a gay dating profile of the lead detective online. What is wrong with this family? Why does she have so many enablers? Listen here, Kouri's mother and brothers, what are you doing? What are you doing? This is not high school. We're not playing Petty Betty over here. Like, stop it. This is like a murder conviction. Okay. The defendant also made an unfounded criminal complaint to the FBI about Eric Richins' business partner. Wasting people's time. The defendant's character is evident, despite her well-crafted facade. Eric surviving Valentine's Day, 3 years of pretrial detention, and a resounding guilty verdict has only amplified the worst of her character. It did not remedy it. She has expressed no remorse and has indeed publicized the opposite. The irrational nature and circumstance of the aggravated murder, its irreparable impact on Eric Richins' family and others, and the defendant's irredeemable character prove overpowering aggravation. Any mitigation the defense presents will only be more facade. It is all she has. But even if credited, it cannot outweigh the aggravation. Accordingly, the defendant has earned the maximum punishment. Short of death, and public safety requires her permanent incapacitation. She has well established that rehabilitation is beneath her. LWOP, combined with the intense publicity cultivated by the defendant and her counsel, will also deter would-be poisoners from coldly murdering their spouse and their child's parent. Well, one can only hope so, right? The court should sentence consecutively on counts 2 to 5. So it says, the gravity of the attempted aggravated murder is that the defendant learned from her mistakes. She learned to obtain something stronger and to administer it in a way that prevented Eric from realizing the poison's effects until it was too late. The circumstances of the attempted aggravated murder are identical to the circumstance of the murder. The gravity and circumstances of the frauds and forgery punch above the charges weight because they encompass the defendant's motive for murdering Eric and the pecuniary gain aggravator. The defendant's character, as discussed in, and there's a reference there, Supra, is irredeemable. Accordingly, the defendant earned distinct punishment for counts 2 to 5, and the court should sentence them consecutive to any other sentence. The court should enter a continuous protective order in favor of Eric Richins' family members. The defendant was convicted of domestic violence, aggravated murder, and attempted aggravated murder. Utah's Criminal Protective Order statute provides that when a perpetrator is convicted of a domestic violence resulting in a sentence of imprisonment, that is to be served after conviction, the court shall issue a continuous protective order at the time of sentencing, limiting the contact between the perpetrator and the victim, unless, 1, the court determines by clear and convincing evidence that the victim does not have a reasonable fear of future harm or abuse, and the protection may include any order the court considers necessary to fully protect the victim and members of the victim's family. Utah Code, right? Here, Eric Richins is the only victim under Utah's crime victim statute. Paradoxically, Eric Richins' family members, including his children, are not victims. It is evident that Eric Richins does not have a reasonable fear of future harm or abuse, which is the Criminal Protective Order Statute's threshold inquiry. Thus, the Criminal Protective Order Statute yields the absurd result that family members of a domestic violence murder victim are left unprotected when family members of all other domestic violence crimes can be protected. This is where the absurdity doctrine comes into play. Courts will apply the absurdity doctrine when the operation of the plain language is so overwhelmingly absurd that no rational legislator could have intended the statute to operate in such manner. This standard is satisfied only if the legislator could not reasonably have intended the result. Okay, so it says this standard is satisfied here. Clearly, the legislator could not have reasonably intended to accept the family members of domestic violence murder victims from protection. The defendant's conduct and the victim impact statements firmly establish that it is necessary for the court to protect CR, AR, and WR from their mother, as well as Eric Richins' father and his sisters and their families. Anyone can appreciate the family's fear resulting from the defendant maintaining insurance on the boys' lives. See State Sentencing Exhibit F, G, and H. Accordingly, the court should issue a continuous protective order. I like that. Okay, continuous protective order under Utah Code, and there's a whole number there, that prohibits the defendant from contacting Eric Richins' family members unless they first initiate contact, which I'm sure they won't, and prohibits her from maintaining or benefiting from insurance on the lives of the 3 boys. 4, the court should order the defendant to pay restitution. Utah's Crime Victims Restitution Act requires district courts to determine restitution for any pecuniary damages, approximately, caused by a defendant's criminal conduct. Insurance companies are victims under the statutory definition. Additionally, the defendant is a killer within the meaning of Utah's so-called Slayer statute, which provides that a wrongful acquisition of property or interest by one who kills another shall be treated in accordance with the principle that a killer cannot profit from the killer's wrong. Yeah. The defendant received over $1 million from Auto Owners Insurance Company and over $350,000 from True Stage Insurance Company as the beneficiary of insurance on Eric's life. That's so sick. These insurance companies paid out as the result of the defendant committing aggravated murder as convicted in count 1. Moreover, True Stage paid out because the defendant committed insurance fraud and forgery as charged in counts 3 to 5. Accordingly, the court should order the defendant to pay restitution to Auto Owners Insurance Company in the amount over $1 million and True Stage in the amount over $350,000. 5, the court should order the defendant to pay recoupment to Summit County. After Ray, Quinney, and Nebeka abruptly withdrew from this case in May of 2024, the court declined to require the defendant to complete an affidavit of indigency, citing Fifth Amendment concerns. Order appointing indigent counsel. The court found that the defendant was indigent on the sole basis of former counsel's representation that the defendant does not have access to financial resources sufficient to retain private counsel. Summit County thus became statutorily obligated to provide defense services to the defendant, and they said the costs of these are over $1.3 million, and they wanted to pay it back. If the court learns that an individual provided with indigent defense services is in fact not indigent, the court shall order that the individual to pay the indigent defense system the cost of the services. There's Utah Code. The defendant continues to litigate claims to Eric's premarital home and a share of the trust res. Like, why is she doing that? To litigate claims. Yeah. The other charges, right? To the extent any of these assets or any other asset are adjudicated to the defendant's property, the court must order over the $1.3 million of those assets paid to Summit County as recoupment for indigent defense services. Additionally, the court may order a defendant to pay costs for expenses incurred by a political subdivision of the state for attorney fees of counsel assigned to represent the defendant. To the extent that the defendant or her representatives or assignees receive any money that is not subject to the Profit from Notorious Criminal Activity Act, the court should order the $1.3+ million of that money be paid to Summit County as recoupment for indigent defense services. Conclusion: the court should sentence the defendants to life without parole among the state's other sentencing requests. This sentence is appropriate considering the crimes that she committed, their impact on her children and Eric Richins' family, and her irredeemable character. This sentence serves the interests of society which underlie the criminal justice system. Most importantly, no other sentence can provide the three boys the comfort and protection that they need and deserve. Oh man, I cannot wait for sentencing. So I will see you there. May 13th, 2026. We're watching it together, and I just can't wait to see those victim impact statements. Oh my word, Kouri Richins Benson, give it to Kouri. Everybody, get up there and absolutely hand it to her. We're gonna have to get through the defense's witnesses, right, and being like, please don't sentence her to life without parole, because you know what, I don't know what sob stories are we hearing, what are we going to hear about her glowing character, not. I wouldn't even get up there if I was them, but we know they're gonna. So I will see you there. I'm looking forward to reading your comments. Comment below, please like and share, make sure you are subscribed with your notifications on, and if you want reliable notifications, you can also join Patreon. You can even just join the free tier, right? And I will notify you with what's happening there, coming up on YouTube, live streams, things like that. All right, everyone. See you there. Justice for Eric Richins and on his birthday. Can't wait.